Hello and welcome to the Minimum Competence episode for Tuesday, May 13th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we've got Trump ousting the Copyright Office chief after an AI report, Texas handing $1 billion to private schools while starving public education, and Trump undercutting voluntary tax compliance. Let's remember, discourtesy is unspeakably ugly, and read today's legal news. On this day in legal history, May 13, 1963, the U.S. Supreme Court issued its landmark ruling in Brady v. Maryland, fundamentally reshaping criminal procedure and the obligations of prosecutors. The case involved John Brady, who was convicted of murder in Maryland state court. Although he admitted involvement, he claimed he did not commit the actual killing. During the trial, the prosecution withheld a statement from Brady's co-defendant that supported this claim. After Brady was sentenced to death, his attorneys discovered the statement and appealed, arguing that suppression of such exculpatory evidence violated his constitutional rights. And the Supreme Court agreed, holding in a 7-2 decision that suppression by the prosecution of evidence favorable to an accused who has requested it violates due process, regardless of whether the prosecution acted in good faith or bad faith. This principle became known as the Brady Rule, and it remains one of the cornerstones of a fair trial in American criminal justice. The court emphasized that the goal of a trial is not to win a case, but to ensure justice is done. The Brady decision led to a broader understanding of prosecutorial obligations and placed enforceable limits on government discretion. Over time, it has been extended and clarified through subsequent cases, shaping what material must be disclosed and when. Still, Brady violations continue to arise in courts, often forming the basis for appeals or post-conviction relief. The ruling reflects a deep constitutional commitment to due process and underscores the state's duty to act not only as an advocate, but also as a guardian of fairness. President Donald Trump abruptly fired Shira Perlmutter, the Register of Copyrights, on May 10th, just 2 days after also dismissing Librarian of Congress Carla Hayden, who had appointed Perlmutter in 2020. The U.S. Copyright Office confirmed the termination via a statement, noting that Perlmutter received an email from the White House informing her that her role was ended, quote, effective immediately. The administration has not publicly explained the firing, and Perlmutter has not commented. The move came shortly after the Copyright Office released a report addressing how generative AI models interact with copyright law. The report urged caution on government intervention and emphasized the importance of voluntary licensing systems. It drew a line between research-related uses of AI, which are unlikely to harm copyright holders, and commercial uses that replicate copyrighted content, especially when done through unauthorized access, arguing the latter may exceed fair use. Representative Joe Morell from New York condemned the dismissal, calling it an unprecedented power grab and linking it to Perlmutter's refusal to support Elon Musk's push to use copyrighted material for his AI training. The timing of her removal, coming 1 day after the report's release, has intensified speculation about political motives behind the firing. Everything is bigger in Texas, including policy failures. The latest, an expensive exercise in public policy theater that trades taxpayer dollars for ideological victory laps. With Governor Greg Abbott poised to sign Senate Bill 2 into law, Texas is now on track to funnel $1 billion away from public education and into private schools, starting in the 2026-2027 school year. And make no mistake, this isn't about school choice, it's about abandoning public schools under the rhetorical cover of parental empowerment. Supporters say it's about letting families choose the education that fits their child's path, but the real fit here is between a regressive policy and a Republican donor wish list. Up to 20% of the funds will be available to families earning over $160,000, so yes, the state is subsidizing private tuition for households that already have the means. Meanwhile, the public schools left behind are told to make do with less. Texas already ranks 38th in the nation in per-student funding, and public schools are still reeling from the $7.6 billion lawmakers withheld last session to hold them hostage for this very proposal. Districts have been cutting staff, closing campuses, and hiring uncertified teachers to stay afloat. Now they're being told they can have their crumbs, so long as the chunk of the loaf goes to private institutions that aren't accountable to the same standards, can't be compelled to admit students, and won't have to administer the same state tests used to judge public schools. This is a policy that spends public money without public accountability. It privileges private choice over public obligation, and it's being sold with the same warmed-over talking points that ignore what the data keeps telling us. Vouchers don't reliably improve academic outcomes, especially not for the low-income students lawmakers claim to be championing. But the most corrosive effect isn't just fiscal, it's philosophical. When a state government diverts taxpayer dollars to schools that don't have to serve every child, it's not expanding opportunity. It's signaling that public education is optional, a backup plan, a place for the kids who didn't win the voucher lottery. Texas isn't innovating, it's retreating, and when the dust settles, it won't be the parents cashing the checks who pay the highest price. It'll be the millions of Texas students left in schools that the state funded just enough to fail. My column for Bloomberg this week focuses on the quiet but dangerous implications of President Donald Trump's plan to reassign IRS criminal investigators from pursuing tax crimes to enforcing immigration law. This isn't just bureaucratic tinkering, it's a direct hit to the fragile deterrence model at the heart of our voluntary tax system. That system relies on the perception that the IRS is always watching, even if the chance of an audit is relatively low. When that perception erodes, so does compliance. I argue that this shift weakens a key psychological pillar of tax law, the belief that evading taxes carries real consequences. Without the looming presence of tax enforcement, some taxpayers begin to wonder, sometimes out loud, whether they still need to play by the rules. I've seen this firsthand in conversations with clients and students. The risk of non-compliance starts to look more like a gamble than a crime. Public, high-profile enforcement has always served a broader messaging purpose: make examples of a few to deter many. But moving agents away from tax cases undermines that strategy and signals that enforcement is now a political tool, not a consistent application of law. Once that belief spreads, taxpayers may stop viewing a payment as a civic duty and start viewing it as optional, especially if they believe others are getting away with cheating. I close by warning that this perception shift, once embedded, is hard to undo. Tax compliance is held together by trust as much as enforcement. Undermining one weakens the whole system. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, we are always remaking the past. History is not what happened, it is what we believe happened.